I'll briefly present you what the situation is with shared parenting in Bulgaria. Under the Bulgarian law, it's very interesting, in fact, because Bulgarian constitution in Article 47 said that the conditions and procedure for limiting or withdrawing parental rights shall be determined by law. This law, which withdrawing parental rights by the court, is the family court, and it is completely different procedure in which take part public prosecutor. So it's very difficult in Bulgaria to take back to deprive some parent from his parental rights. In fact, under the Bulgarian law, if we read correctly Article 123, it's easily to remember 1, 2, 3. The parental rights and obligations shall be exercised in the best interest of the child by both parents jointly and separately. Where a parent has acted alone, he shall be obliged to notify the other parent. For me, this is a clear norm in Bulgarian law which prescribed judicial shared parenting. The alinea 2 of this article means the exercise of parental rights and obligations shall be carried out by common consent of the parents. Is it clear? It's completely clear. In the event of disagreement, they may apply to a mediator or bring the action before the district court of the child's present address, and in which shall decide the dispute after hearing the parents and, if necessary, the child. The court decision may be appealed, etc., etc. So, what the problem is? The problem is another norm in Bulgarian law, which is Article 127 and Article 59, which prescribe, can you imagine, if the parents do not reach an agreement, the dispute shall be resolved by the district court of the child present address, which shall rule on the child's residence the exercise of parental rights. What the exercise of parental rights means? I amuse myself every time to ask the judges, my colleagues, lawyers. Nobody can tell me what does it mean in every dispositive of Bulgarian judicial decision. It's written the parental rights shall be exercised by the mother or by the father. And I ask, what kind of right is done to this mother or this father, which they didn't have yet, and what kind of rights, parental rights, are taken by another parent? No one. So both parents still exercise commonly the parental rights. In that case, why Bulgarian courts make this disposition? Again, the exercise of parental rights will be blah, blah, blah. My explanation is perhaps we talk with the Greek colleagues the new laws are exercised by the old judges. There is something in their mind, but not only in the mind of the judges, in the mind of society. The society doesn't, the society can't imagine how to apply this disposition, this good disposition of Bulgarian family code. In fact, I can tell you that all the disputes between the parents in Bulgarian law, in Bulgarian practice, actually, are under this article 127 and 59, which is about who will exercise the parental rights, whatever that does it mean, and the domiciliation of the child, with whom the child will be resident. No one, there's no disputes between the parents upon Article 123, which said, as I told you, if in the event of disagreement, the parents may apply to a mediator or bring the action before the district court. So, as I know, I have enough cases. Because of that, I can be tomorrow at this beautiful excursion on the Greek islands, because I must return to Sofia. So I never seen the cases like that. Never in Bulgarian law. No, because the parents doesn't dispute in which school the child will be taught, but that there's no applicability of this article, and this is some kind of miracle for me. But what happens with the application of shared parenting? Even in this is the legal basis, the Bulgarian courts, and thanks to this Bulgarian judges, which were very activist in this way, they started to apply shared parenting in his own basis, because the law doesn't have disposition about the time. Nothing is set in Bulgarian law about the time. How many time child will be present in each parent. So, because of this good way of jurisprudence, in 2016 has arrived one decision which is compulsory, interpretative decision, number 1 of 2016, which prescribes that, I was just preparing for this presentation. He said, Article 29, paragraph 2 of the Family Code excludes the possibility of the exercises of parental rights jointly to both parents in the event of failure to achieve agreement on their exercise. Well, in my opinion, if you ask me, this interpretative decision is counter-constitutional. It's clear for me, but not for all my colleagues, not for all the judges, not for the majority of the judicial community and all the society. There is a small groups of activists who fight for shared parenting. We proposed more than once to Bulgarian legislator, the text of shared parenting law, which we need very completely necessary for us, but this never happens. We made exercise in the parliamentary commissions, in the Ombudsman of the Republic, ministry by ministry. Every time there's something more important in the Bulgarian politics or at the level of Europe or the world, which is counter this possibility to change the law. How many time I have? What?
5 minutes more.
Sorry?
5 to 7 minutes more.
Okay, thank you. So there is another important thing of which I want to talk to you is the question about parental alienation in connection with the case of shared parenting. Bulgarian legal system is between little ones which has the term parental alienation in the law. This is Article 59, paragraph 6, which said that well, in the case where there is evidence of parental alienation, the court shall hear an expert psychologist. This is a norm with the new, which is not still new, family code from 2009. But in fact, this is only this position which consists the term parental alienation gives us very powerful instrument to use it against this social evil, I can say. So the Bulgarian jurisprudence developed this position, and these days in Bulgaria, if there is a question about parental alienation, the jurisprudence prescribed that it must be find a solution in the court decision. If there is a data of parental alienation, the court is obliged to find a solution or to prescribe a solution. But the good news stops here, because after that, we have no real instruments, or the court hasn't real instrument to prescribe. The only instrument to prescribe against parental alienation is to order social service, which consists some specialists to talk and to both parents, to alienator, to alienated child, and to alienated parent. The problem is that that's never happened. I don't know the case which is which found a solution with parental alienation only with this social service using psychologists. The solution which I found is where with very tough serial cases in the court, the alienator is obliged to act or to change his mind and his way of activity, and happily the result becomes very easy and very fast. I can say immediately. Recently, I had a case which a child doesn't see her father 3 or 4 years, and when the mother changed his opinion, when she talked to him, go with your father, he goes like never before this kind of alienation. In using this experience, I think it will be very useful to change the way of treating parental alienation. First one is absolutely to introduce reputable presumption for shared parenting in Bulgarian law, as in Greece, for example, we use the Greek law for motivate our proper preposition for changing the law. And the second is to provide very compulsory obligation to the to both parents actually, but especially for the to the alienator, because if alienator changed his mind, the problem is very easily resolved. I have in my back the expertise which is for next week of my cases, which are for alienated mothers. What I'm trying to say that we have very important movement against presumption of shared parenting and measures against parental alienation of the NGOs whose defend women against domestic violence. And I ask him every time, what can I do with the women which I defend, which are alienated as well? What to do? And in this expertise, I can show you who are interesting. The experts, this is second expertise. The 3 experts said, we have nothing to do. Let's the child goes on without mother. Well, it's not the way of my thinking. It's not the way as I act. So I think with more pressure of the community, these changes in the law will become the fact in Bulgaria as in Greece. And I hope that this kind of disputes will find the best solution, best even
Okay.
and then in Greece.
Yeah.
So thank you.
And
If you have some questions.
yes, thank